Well, hello there. I am Dr. Jen, and I'm so pleased you've joined me for today. That means you're educating yourself in all things housing. And in particular, today we are looking at the location-specific guidelines for the state of Arizona. Here, so I have got one, two, three, four, five hyperlinks in the show notes. So if you haven't already, make sure you're looking at the resources in the hyperlinks. And if you're new to the location-specific episodes, I have the same framework for every single one of these episodes, and I just changed the location. So we answer four questions, and those four questions are, in this case, in Arizona, what are the basics of the Arizona Residential Landlord Tenant Act? And they have an acronym there, ARLTA. I don't know if that's ARLTA. I'm not sure. But what are the basics of the Arizona Residential Landlord Tenant Act? Two, what are the nuances of that act? What are the nuances in Arizona? Sometimes there's kind of weird things, but that's okay. That's cool. The third one is guidance about abandoned items left behind by a tenant in Arizona. And then fourth is where to get help in your local area in Arizona. Those are the four questions that we aim to answer in this episode for Arizona. And then at the very end, I'll go through what I call my bingo card. My bingo card is the list of the most standard items I see when I do these location-specific episodes. And if you haven't been following the show for that long, you'll notice in the library, I have quite a few location-specific episodes, and they're growing all the time. So check it out, especially if you're either owning rentals in Arizona or you're thinking of buying in Arizona. This is a good episode for you. But I must tell you that there may be other guiding documents beyond what I'm going to show you here. Even if I have them all perfect, 10 minutes after I record this episode, laws and things do and can change, right? So not only do you want to make sure that you are most current, that you've got everything applicable to you. I'm just looking at the state of Arizona, but there may be other things in your regional district, your county, your municipality, something that I don't know about because I am just going to give you a way in to help yourself and to get you started in Arizona. I'm going to give a shout out to today's sponsor, Aloha Capital Investments LLC. If you want to know what Mike and I are doing in real estate or you want to be a part of our real estate investing, check out alohajv.com. We've got all kinds of fun things going on all over the place, most of it in the US. Not all, though. Okay, so if you're watching it, My Life as a Landlord on YouTube, you're going to see me screen share. And what I'm going to do is I'm going to show you the resources I have in the show notes. We're just going to walk through them. And so I've got the five hyperlinks here on the screen. And this is a Arizona residential tenant landlord tenant law. So this one is about the guide. There's all kinds of different things in here, but I'm just going to go straight to landlords. If you're listening to the show, chances are good that you are a landlord. So we're going to go right into landlord introduction. Let's see, move-in duties. Move-in duties. Landlord must disclose. You've got to give all your contact information, right? You've got to make sure that you've got all ways of getting a hold of you or your agent. And I like this. Landlords must provide tenants with a move-in inspection form to record any existing damage to the resident. In fact, it's a good idea to not only just provide the tenants with a move-in inspection form, but actually do the move-in inspection form with the tenant. Have your agent do it with the tenant. Okay, and it's the form. The writing is the key here. Yes, you can take pictures and you can take videos and things like that, but the courts, if it goes to court, for whatever reason, what they want to see is the form. So you've got to provide the form in Arizona. Further, in Arizona, landlords who rent property with access to a swimming pool must provide the tenant with a pool safety notice. So it doesn't necessarily mean that there's a pool on the property, although that applies, but it looks like if they have access to a swimming pool, like in an apartment complex with a pool, then you've got to provide them some safety information. And then federal law is notice about lead-based paints. That's regardless of wherever the location is, right? Swimming pool, lead-based paint. Also, as a landlord, you've got a duty to maintain your residence, got to be habitable, comply with building codes, maintain all appliances in working order, provide running water, reasonable amounts of hot water, and reasonable amounts of hot water is always a question. I saw a post on Facebook today about a tenant complaining about lack of hot water. You've got to always provide reasonable amounts of hot water, and potentially, if that's not the case, then you need to think about the size of your hot water tank. Also, heating and air conditioning when required by the weather. So then it talks about the costs in here. And the remedies in the event that you don't provide the essential services as a landlord, that the tenant has several remedies. Basically, they can leave, they can fix the thing themselves, send you the bill. Yeah, give you notice of failing to do this. Non-payment of rent. If a tenant fails to pay the rent promptly, the landlord may collect all reasonable charges specified in the rental agreement. So you've got to make sure that you have a late fee of some kind, whether it's a flat rate fee or a percentage of the rent. And typically we haven't been into the tenancy laws a whole lot yet, but there might be some wording about what's the maximum the late fee could be. But further in here, it says when tenants have fallen behind in their rent payments, landlords must notify the tenants that they have 5 calendar days in which to pay past due, or the rental agreement will be terminated. And then you've got how to serve. That's always something, is how do you make sure you serve them. Further, landlords cannot raise the rent to specifically retaliate against a tenant complaining about housing code violations, joining a tenant union, or failing to keep the dwelling fit. This is known as landlord retaliation, and typically there is a timeline that landlords within a certain timeline can't try to evict and then retaliate by raising the rent, decreasing the services, or let's see, what was the other one? Decreasing the rent. Let me make sure I got them all. Decrease the services, time of eviction. Yeah, that's it. Okay, so no landlord retaliation. I get it. Landlords don't have to accept partial rent payments. That's always a question, especially if a tenant is behind in rent. You do not have to. If they do submit a partial rent payment without getting a written agreement when the remainder is due along with any other terms, they waive their rights to terminate the rental agreement on a particular breach. Okay. If the tenant is in breach of the rental agreement, this is usually due to mischief, not due to non-payment, then the landlord can deliver a written notice to the tenant stating what the tenant did or didn't do, and the rental agreement will terminate unless they breach it. It says terminate upon date not less than 10 days after receipt of notice. So 10 days, that's actually pretty quick, especially if someone is misbehaving. Let's see. Yeah, landlords can't change the lock. You can't cut off essential services. You can't cut off utilities. Generally limited to situations when the tenant has abandoned the property or when the tenant has been evicted. So there's some gray area in there. And then landlord created rules. So if you have house rules, then the rules cannot have the purpose of evading the landlord's obligation, and new rules require 30 days notice to existing tenants. Of course, if you change the house rules, like moving smoking areas, things like that, right? Landlord entry into rentals. So this is access into the rental. You must provide 2 days advance notice of the landlord's intent to rental, reasonable time, and it must be a reasonable excuse of why you need to enter. So repairs, alterations, improvements, tenants cannot unreasonably refuse to allow landlord into the residence. And in case of emergency, anything you would call 911 for, landlords can enter without consent and without notice. That is for safety of person and property. Landlords are prohibited from abusing access or using it to harass the tenant. That's correct. I agree. I agree. So you've got all this. So this is the University of Arizona College of Law Library. And just Googling Arizona tenancy law, this came up. And there's a couple other spots in here that I would like to take a look. Let's look at the tenant's part of this. So the tenant's duty to maintain the premises, month-to-month rental agreement. So you've got, if a tenant or landlord wants to terminate, they've got to give the other party 30 days notice. And a maximum a security deposit can be is 1.5 months rent in addition to the first month's rent. Now, remember, when we're talking security deposit, it's all money, but it's different when you're talking about deposit and you're talking about rent. Rent is paying for a service. You're paying for a product, right? You're paying to rent a unit. So that is different. That is actually revenue for the landlord. But when you're talking about the security deposit, in this case for Arizona, 1.5 months rent for security deposit, you're actually holding the tenant's money. So typically it is in a separate account. We're going to see here if it's a requirement to be in a separate account, but it's best practice that it should be in a separate account, not an operating account, because it's not your money. It's the tenant's money, right? So, but think about that. If this unit that this person is trying to rent is $1,000, they've got to come up with a month and a half worth of rent for security deposits. So that's $1,500 plus first month's rent is another 1,000, so $2,500 they've got to cough up. So again, dealing with security deposits, within 14 business days after termination of tenancy, landlords must refund all of the security deposit or the remainder after taking the deduction. And then if deductions are taken, landlord must provide a written itemized list. So you want to make sure that you are taking notes, that you do a condition inspection form. Again, I know it's a requirement in Arizona that you actually provide the form, but it's easier, especially if you think that you're going to deduct, and I always anticipate that we're going to deduct, even though I hardly ever deduct anything. I always want to make sure that we do our condition inspections and move in and move out. Let's see. Landlords must also give written notice that the tenant may be present during the move out inspection that will be used to determine the deductions in the security deposit. However, the landlord does not have to meet this requirement if the tenant is getting evicted for material breach of lease or fear of violence, right? This is going to come up more. Refusal to rent. Landlords can refuse to rent as long as the refusal is not based on an improper reason. This is interesting. For example, landlords cannot refuse to rent to families with children unless the rental dwelling is in a subdivision or area restricted to adults only by formal deed restrictions, or which qualifies as housing for older persons under the Fair Housing Act. So you cannot refuse based on familial status, right? As a protected status. If a landlord breaches the rental agreement, the tenant may demand a written notice to the landlord saying that, hey, this wasn't it. You've got to fix this within 10 days. And if the material breach affects the health and safety of the tenant may deliver a written notice that they either need to correct it or the rental agreement will terminate 5 days after it. 5 days, right? I mean, if you've got a health and safety issue, I understand. So it's saying the only time rent can be withheld is when a landlord has either deliberately or negligently failed to supply running water, utilities, reasonable amounts of hot water, heating, air conditioning, etc. And of course, there's hyperlinks all through this on the more details, right? This is just super high level, which is fine. This is all I want to do in this episode is get you started. So if you're in a situation and you need to do more, then you can Google and there'll be some more resources as we go through the episode here, but you can, click on any one of these and they'll jump to it. Now, of course, there is Arizona Department of Housing has provided a Arizona Residential Landlord and Tenant Act. This is sort of a guide, and we'll go through some of this, but it does include some things that doesn't particularly apply to us, like pertaining to hotels and innkeepers. There may be some other ones in here regarding mobile home parks as well. So remember that tenancy law is indeed a law, and so it can be very legal looking because it is. And then these, of course, this is neat how they've done it where they're the hyperlink. You just jump right to it wherever it is. That's kind of cool. Security deposits, disclosure, regulating of rents, transfers of record on sale. I think we've gone through a little bit of this already. Self-help, wrong for failure to supply heat, air conditioning, cooling water, hot water, or essential services. Yeah, abandonment. In fact, let's jump to abandonment right now. I think I've also got another abandonment item. I do. I've made abandonment. Here's abandonment. It's its own special hyperlink, but I'm going to go to it now. So this one, if a dwelling is abandoned after the time prescribed in section J of the section, so whatever time that they're supposed to either be out because of an eviction or out because of notice to terminate, the landlord should send a notice of abandonment by certified mail, return receipt requested, addressed to the tenant's last known address, which could be the unit, right? Could be that unit, and to any of the tenant's alternate addresses known to the landlord. And you've got to post a notice of abandonment on the door all for 5 days. You've got to post it for 5 days. So you basically can't go in. 5 days after the notice of abandonment has been both posted and mailed, the landlord may retake the dwelling unit and re-rent the dwelling at fair market value if no personal property remains in the dwelling unit. This is where it gets interesting. After the landlord retakes the dwelling unit, money held by the landlord as a security deposit is forfeited and shall be applied to the payment of any accrued rent and other reasonable costs. So here's the other one is what do they do with the personal property? Um, Okay, hang on a second. So, yeah, if the tenant abandoned, okay, so this is about re-renting it. Okay, let me keep going here because I'm thinking more about personal property and it's not gone that way. It's if the tenant abandons the dwelling unit and the landlord should make reasonable efforts to re-rent the dwelling unit at a fair rental. And if the landlord rents it, then the rental agreement is deemed to be terminated with the old tenant that abandoned the unit, right? If the landlord fails to use the reasonable efforts to rent the unit at the fair rental, or if the landlord accepts the abandonment as surrender, the rental agreement is deemed to be terminated by the landlord as of the date, as the notice of abandonment. Mhm. If the landlord retakes possession of the dwelling unit and the tenant's personal property remains in the dwelling, the landlord should prepare an inventory. This is important. Inventory and notify the tenant of the location and cost and storage of the personal property in the same manner prescribed in Section A of this section. Okay. Now, they've got to inventory everything and then they've got to store it. Now, then the question is, how long do they have to store it? And then when can they dispose of it? How is that done? So let's keep going because it can get a little bit tricky, which is why I included this in each framework because this can get really messy. And if you do it wrong, it can get painful. Okay, landlord, abandoned unit, personal possessions, available unit, storage space owned by the landlord or off premises. The landlord is not required to store the tenant's perishable items, plants, and animals on behalf of the tenant. The landlord may remove or dispose of as appropriate the perishable items, including plants, and at the landlord's discretion, the landlord may remove or dispose of the personal property in the dwelling unit that is contaminated, may be considered a biohazard, pose a health and safety risk, which you can see that you're getting into mold and potential hoarding situations and things like that, especially if you've got animal feces, or geez, it could just be a mess in there. So you've still got to try to alert the tenant that you've got personal property. After notifying any person who is authorized by the tenant to retrieve the tenant's animal, this is about animals who've been abandoned. No retrieval occurs after 1 calendar day. The tenant's abandoned animals may be immediately removed and released to a shelter or boarding facility. That's good. So of course the landlord still has to keep record of the name and location of that, or provide reasonable care. So the landlord is not liable for actions taken in good faith related to the removal, release, seizure, care of abandoned. This is amazing. It talks about abandoned animals in Arizona. I mean, is this a thing? I guess so. So then let's talk about the person's property that the landlord has in storage. The landlord shall hold the tenant's personal property for a period of 14 calendar days after the landlord retakes possession of the dwelling unit. The landlord shall use reasonable care in moving and holding the tenant's personal property. And if the landlord holds the property for this period of time and the tenant makes no reasonable effort to recover it, the landlord may donate the personal property to a charitable organization or otherwise charity, or sell the property. If the landlord sells the property, the landlord shall retain the proceeds and apply them to the tenant's outstanding rent or other costs. Wow. And then here it is. After, if you sell the personal property, you got to still keep your inventory. But this is even crazier. For a period of 12 months after the sale, the landlord shall keep adequate records of the outstanding and unpaid rent, and the sale of the tenant's personal property, and then hold for the benefit of the tenant and any excess proceeds that have been returned as undeliverable. So the landlord can't take back the proceeds. And then if the tenant pops up and says, they want their money or their stuff, they basically have 5 days to reclaim the personal property. To reclaim the personal property, the tenant must only pay for the costs associated with the removal and storage for the period of the personal property. Basically, if they owe back rent, that's over. That, right? Goodness sakes. Um, oh, and then they define abandonment. So let's define abandonment. The absence of the tenant from a dwelling unit without notice for the landlord for at least 7 days. If the rent for the dwelling unit is outstanding and unpaid for 10 days, and there's no reasonable evidence other than the presence of the personal effects of the tenant, or the absence of the tenant for at least 5 days if the rent of the dwelling unit is outstanding and unpaid for 5 days and none of the personal properties is in the dwelling unit. So it's 5 days if they've basically completely emptied the unit and gone and the rent is unpaid, or it's 7 days if their stuff is still in there. Interesting. Okay. So that's abandonment. I'm going to go back in here. We were looking for things like late fees. What about pets? We'll talk about pets as well. Haven't seen any of that yet, and we may not. Okay, before we go and do a deep dive into here, because this is 50 pages, I'm not going to go into this too far. Let's go and check out the other links here. We've already done the abandonment one, which was the 5th link, but let's go into, this is azcourthelp.org, and this is the Arizona Bar Foundation. So they want to make sure you can get some resources for yourself, which is great. So it's talking about the Arizona Residential Landlord Tenant Act, which is the law that governs residential tenancies. And you can get a free copy of it by visiting the Department of the website. There it is. And defines everything, how this all works. Short-term crisis program, Landlord Tenant Act, legal aid resources. In fact, I'm going to click on that. And lots of videos. That's cool. Arizona, well done. And then free legal services. In fact, I'm going to go ahead and I'm going to put this in the show notes because this looks pretty helpful. So I'm going to go ahead and put that in as well. And talking about legal aid, low cost legal aid, lawyer referral services if you think you might need a lawyer. And then they typically, this is very typical in different locations. For a very low fee, usually less than $50, someone will work with you for a 30-minute consultation to just guide you on your specific information. They're not, I mean, they might represent you in the event you end up going to court, but they can just guide you and maybe even provide some documents. Who knows if they can do that. So additional legal sources can be found here. I'm going to go ahead and open up this link because it might also be helpful. Let's see what it is. It looks like it's a broken link. Yeah, it's broken link. So that's there. Yeah, if you need help preparing a document, you may want to hire a certified document preparer. Let's just see. It's a directory of document preparers. General information. Interesting. Legal document preparer program. Okay. Okay, resources. I'm just going to kind of go down this rabbit hole here because if there is some forms, which it doesn't look like there is, and this is the judicial branch. This looks like it is the Arizona Supreme Court. Yeah. Cool. Well, this is all kinds of help in here. Like if you're looking for different things or you're looking for some info, or maybe you've got a lease that you're not sure if it's going to hit all the high points. I mean, it might be worth your $35 to just get a quick consultation from one of these referred lawyers, which is kind of cool. So you've got some legal aid and then you've got some videos as well. Okay, let me keep going. So this is landlord and tenant disputes and eviction. This is azcourts.gov. Again, this is the Supreme Court. This is a little bit different from the last screen we were just in, but you can see that there is quite a bit of, we can go down some of these. How about we just do forms and notices? Because that's usually one of the questions that people have. So here is some forms. This is actually really nice. You've got all kinds of court forms. Failure to pay, 5-day notice to pay. Let's just look at this form. All right. Okay, so it looks like you can download it and you just fill it out. So this is actually pretty standard. I've seen this before. I've seen this exact form before, but it is very likely adjusted for, yeah, for Arizona. So, and then it says eviction help, please visit, and there's hyperlinks through here. So make sure that you read it and um, really just make sure you're clear on what's going on. Landlord may file an eviction. So yeah, you want to make sure you're serving everybody properly. I'm going to go back. Health and safety violations, material breach. Let's see, this is a mischief one. Notice, 10-day notice to comply. Yeah, fix or correct the problem or basically get out. Yeah. Okay. So these are, and then it gets into eviction forms. These are court forms. So counterclaim, writ of restitution, appeals. So this is not like warning letters or anything, but let's go in here. Notices before, oh, this is the same one. Notices before the lawsuit. Okay. Um, yeah, so they've got a disclaimer here as well. The forms available on the site are generic and may be accepted by the courts statewide, may be accepted. Please note that each court may have their own preferred forms. And if this is a question, wherever you are, talk to your county clerk, the county seat, just call the county seat and say, I have this question, what do I do here? What form do I use? They will very likely be able to help you. But you can also go to azcourthelp.org for more court-specific forms. Yeah, eviction forms. Okay, so we've seen that. Okay, so let's go back to the Landlord Tenant Act from Arizona Department of Housing and keep going because we've got some of this. It's a little disjointed, but let's keep going. This talks about pets. Okay, let's talk about pets. Okay, rent shall be payable. Da, 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 da. Okay, so it's talking about animals here. I'm trying to not read too much, but it's talking about, here we go. If notwithstanding, the landlord may request and the tenant may provide a routine update on the name and contact information of the person who is authorized by the tenant to enter the tenant's dwelling unit, retrieve and store tenant's property, including the tenant's animal, if the tenant dies or it is otherwise incapacitated. This is really important. This is on my bingo card. If the tenant is unable to contact the authorized person at the address and telephone number provided to the landlord by the tenant, or the authorized person fails to respond within 1 day for the animal or 10 days for all other property, the landlord may dispose of the property as described in abandoned items, which we just went through, or remove the animal to an animal shelter. Yeah. The landlord may release the animal to a relative of the deceased or incapacitated tenant if any one of the following applies. The landlord was not provided the contact information of a person who is authorized to retrieve the animal. The contact information is no longer valid, or the landlord is unable to contact the authorized person after 1 calendar day. Yeah, you don't want to make that animal suffer. Interesting. Okay, so this next section, I'm on page 9, talks about utility charges, submetering, water system exemption, prohibited provisions in rental agreements, which is pretty standard. That's unconscionable. And that's you can't incriminate yourself. You can't exonerate the landlord. You have to completely play by the act, right? You can't just, yeah. Okay, no discrimination. We talked a little bit about that already. Early termination by the tenant due to basically some criminal stuff, including domestic violence, sexual assault requirements, lock replacement, access refusal, trouble damages, and immunity. Hmm. So you want to make sure that your unit is always safe, quiet, comfortable, right? And safe is the key word there, right? And so if you've got someone who has had a sexual assault or domestic violence, especially at the property, you want to make sure you've got the locks dealt with or allow them to terminate their lease. That's part of this. Early release termination for law enforcement officers. Okay. Hmm. This talks about bed bugs. Every once in a while, I get a location that has lots of bed bugs. I think that's because maybe it's Arizona is really dry. I don't know. Hmm. Okay, so landlord obligations, security deposit. Landlord shall furnish the tenant with a signed copy of the lease. So you do have to deliver a signed copy of the lease. Yeah, and then this talks about an application fee. It says any fee or deposit not designated as non-refundable is indeed refundable, right? It is refundable. And let's see, on the request of the tenant, termination of tenancy. We've talked about prepaid rent, security deposit. The unit has to remain habitable. Regulation of rents. So this is really interesting. This is one of the things that they're talking about, and I'm at 33-1329. This is on page 17, regulation of rents. Notwithstanding any other provisions of the law to the contrary, the state legislature of Arizona determines the imposition of rent control on private residential housing units by cities, including charter cities and towns of statewide concern. Therefore, the power to control rents on private residential property is preempted by the state. Cities, including charter cities or towns, shall not have power to control rents. But this is exactly why you've got to do your own homework, because in Arizona, if you've got a special area that, the city is dictating what you can do as far as rent increases or rent control, things like that, you've got to know that stuff. So I can see that they've pushed this down, they've delegated it, but I can't see what it is. And even if I said what it is, they would, by the time you're listening to this, even if you're listening to it 5 years later, I'm not going to say what it is because you need to know what it is in your area currently, right? Okay, so now we're talking about transfer of records. So if you sell the property or it's foreclosed on, that impacts the lease, the requirements for the tenant to maintain the dwelling unit, rules and regulations, access. We've already talked about abuse of access. Non-compliance by the landlord, self-help for minor defects, wrongful failure to supply heat, air conditioning, cooling, water, hot water, or essential services. That's a big no-no. Please make sure you're keeping the unit habitable. Abandonment notice. Okay, so we've already gone through all the abandonment stuff. That's quite a bit. That's a lot. Landlord liens. No, remedy after termination. No, holdover remedy. So it looks like periodic tenancy. It looks like if you've got a fixed term tenancy that it does end abruptly, it does not automatically roll over into month to month, which means you can terminate it if you're in a holdover situation. Okay. Removal of guest. Oh, this is always fun. A person who is a guest of a tenant who is not named on a written lease and remains on the premises without permission of the tenant or the landlord, basically a squatter moves in, is not a lawful tenant, and that person's presence on or in the premises does not constitute residency or tenancy. A person who knowingly remains on the premises without permission of the tenant or the landlord may be removed by a law enforcement officer at the request of the tenant or landlord who isn't, or a landlord who is entitled to the possession of the premises. So this is key. If the tenant is still there and this person won't leave, the tenant's got to call the police because then they've got someone in. If the landlord is in possession of the unit and someone won't leave, then the landlord has to call the police, it seems like, right? Removal of guest. Remember, it's not saying another tenant, it's a guest. They should just basically say squatter, but still. Okay, retaliatory action prohibited. True, true. Um, this is if the tenant has complained to a governmental agency about the habitability or organized or become a member of a tenants union or complained to the landlord about something going on, then the landlord cannot retaliate within 6 months. And this is always what I'm looking for is what's the timeline? Because within 6 months of something occurring, the landlord cannot file for eviction, usually increase the rent or decrease the services. And so that's considered landlord retaliation. In Arizona, it cannot be within 6 months. Everybody has to play nice for 6 months. Okay. Oh, this talks about slum properties. Oh boy. Okay. So the only thing I saw about pets was making sure that you had an emergency contact in the event the tenant is either has died or is incapacitated so that the pet has somewhere to go. But I didn't see anything about a pet deposit or pet rent or anything like that. Interesting. Property inspections, health and safety. Yep. So the city might conduct, depending on where you are, the city may conduct inspections themselves to ensure its habitability. This is about innkeeping. I'm not going to go through this because that's not who's listening to this show. And forcible entry and detainer. So this goes into taking back the unit, although demand for jury trial procedure. This is getting pretty serious here pretty quick. And I think that's the end of it. Yep. Okay, so we've got a little bit of guidance here, giving you a few references for help. azcourthelp.org looks like you've got some in here. And then I'm going to click on the Bar Foundation because I haven't seen. This is azbf.org, which stands for Arizona Bar Foundation. And this is the legal services. So I'm actually going to add this into the show notes so that you have this one as well, because this seems interesting. Okay. Hang on just a second here. I want to fix this. Arizona Foundation for Legal Services and Education. Okay, so let's go through this. So this is, I need legal help. So if you're in here that you would go into legal help. In fact, I'm going to scroll down to the bottom because if they've got a phone number that you can call, I want to make sure that you can see that as well. So it does look like you've got a number of places. Contact us, supporters. So they're in Phoenix. But there's all kinds of links as you can go through. So here's what we do. So let's say I need legal help. Let's go down this rabbit hole for a sec. I need legal help. Okay. So this is basically everything that I put in here except for, I haven't put American Bar Association free legal answers, but azlawhelp.org, azcourthelp.org, and then you've got a bunch of other ones depending on like Law for Seniors, Court Care, Bar Association free legal answers. I'm going to put that in there as well. Okay. So you've got that. That is all American Bar Association for Arizona. Let me fix that as we go. American Bar Association for Arizona. Done. Okay, so that's in the show notes. So now you've got even more hyperlinks. 1, 2, 3, 4. You got 8 now, which is kind of cool. Association. Okay. So let's go into the bingo card. I'm going to stop sharing here. And I hope that you will do a deep dive, especially if you are a new landlord in Arizona and you are just new to this. You really want to get deep in the weeds about what you can and cannot do. So please make sure you're doing your own homework. Okay, so here's my bingo card. Tenant application fee is didn't say anything about it, but it did say if you have something that's non-refundable, then you have to state it's non-refundable. But typically an application fee is reasonable and it actually is mimics real costs, like if you're doing a criminal or a background check or something like that. So it goes in there. But I didn't see anything specifically about a tenant application fee or something like that. Grace period for late rent without penalty. You're going to give a 5-day notice to pay or quit. Did not say anything about a late fee, and we were looking whether it's a percentage or a flat fee or a max amount. Didn't see it. Security deposit can be up to 1.5 months rent. typically in a separate account, but you can also, as an Arizona landlord, we've seen that you can also charge the first month's rent. You're going to need the first month's rent anyway to get them in. Lease wording and details, yes, they did give you a list of the items that you must include in the lease. Is there an emergency contact required in the event of tenant abandonment, incapacitation, death, or imprisonment? Yes, I did say that that there you've got to make, as a Arizona landlord, you've got to make reasonable effort to have this emergency contact on file. That's one of the first places I've ever seen that. That's really interesting, and I'm glad to see it because it's best practices. And as our population ages and more people are aging at home, I think you're going to see more people either they're going to age in place. They're going to end up dying in their units, some of them. So, yeah. Pets and animals, there was some talking about this. In fact, it was talked about when we were talking about emergency contacts about what to do with an animal in the event the tenant is incapacitated or has died. But it didn't talk about pet deposit or pet rent or service animals. Didn't talk about anything. Delivery of signed lease required, yes. Condition inspection at move-in. Well, the landlord has to give them the form, but it's a good idea to do it with them, right? Standard warning letters or wording, no, just no, didn't give you any standard warning letters, but maybe one of the sources for help can help you do that. Required maintenance inspections, no, but they did mention that the government agencies could potentially do inspections as well. Again, a good best practices. How often can the rent be increased? In fact, I don't remember seeing anything about increased rent, proper notice, or how much it can be increased. We might pop back in there in just a second and check that out. So, give me a sec. All right, renter's insurance, is it required to mention, not mentioned? Is access abuse of access defined? Yes. Is landlord retaliation defined? Yes. Is the end of a fixed lease abrupt? Yes. Condition inspection at the time of move out? Yes, especially, in fact, the landlord is supposed to invite the tenant to do it with them, especially if you anticipate deductions from the security deposit. This is good. Return of deposit or bond timing? Yes, we did talk about this. I believe it was 60 days, I believe. Oh boy. And then use of last month's deposit as rent, yes. And there was a lot about abandoned items. So let's go back in and talk. Let's look specifically about the deposit returning and rent increases. I think those were two that we didn't do, but let's go back in and look real quick for those because that's really important that we kind of get some of these answers. Security deposits. Oh, 14 days. Here it is. 14 days after termination of tenancy, the landlords must refund. So 14 days is what you've got. Okay. And then let's talk about rent increases. I know we did do some of this, but let's talk about it anyway. Let's go in here, move-in duties, non-payment of rent. So there was this little blurb in here. Landlords cannot raise the rent specifically to retaliate. And I'm going to click on this because there wasn't really anything about. So this is a retaliatory conduct, which increasing the rent is part of what's considered landlord retaliation. However, when you're talking about rent increases, let's go up to the table of contents in here. When you're talking about rent increases, that is a normal part of doing business as a landlord. So it should be involved. So I'm just looking through the table of contents in the act itself. Early termination, separation of rents. I am not seeing this. Disclosure, maintain to fit premises, limit of liability, regulation of rents. So it seems like in Arizona that the reason why you didn't see anything in the act about rent increases is because it looks like it's delegated to local jurisdictions, right? So wherever you're at, in fact, if you're an Arizona landlord listening to this, make sure that you're aware of what's going on. In fact, since I'm sharing screen, let's just do it here. Let's say I've got a rental in Phoenix. Let's go Phoenix AZ rent increase and just Google that and see what comes up. So here is what it says for Phoenix, Arizona. This is just AI throwing in what it is. I'm looking for something that's not necessarily, but this is what AI is putting together. So it says in Phoenix, Arizona, landlords can increase the rent at any time, but they must follow specific regulations. Notice requirements for a year-long lease, landlords must provide a 90-day notice before the rent increase. For a month-to-month lease, landlords can raise the rent at the end of each month without a specific notice period. Weekly leases, a minimum of 10-day notice is required before increasing the rent. No cap increases. There is no legal limit on the amount a landlord can raise the rent, but they must act reasonably and in good faith. And then it throws this in the last bullet point. Recent trends in Phoenix, rents have increased significantly with reports indicating a 46% increase over the previous year. Wow. Let's do something else. Let's do Flagstaff. Flagstaff, Arizona. Okay, so this one, it just comes up as AI. It says 5% Flagstaff, Arizona rent increase. The average rent in Flagstaff has been a 5% increase. This is according to KNAU, Arizona Public Radio. But this isn't I guess that's just a calculation from like Zillow or something that doesn't tell you what it is. Interesting. Okay, so it is definitely where it's location specific, it's geographic specific. Okay, I'm going to stop sharing. Let's close out this episode as we wind down with Arizona. I'll give you some more resources at the very end, especially if you're a brand new landlord getting started. But let's wrap up this way. Noting again that each of my location specific podcasts is set up in the exact same way, answering the same four questions. What are the basics of that location? What are the nuances of that location? Guidance on abandoned personal property items from a tenant in that location, and then where to get help. Then at the last bit, I go through my bingo card of standard items I see most frequently in tenancy laws in different locations. And so this is the same format for every location specific episode. So if you're thinking of buying rentals in another geographic location, just go to the My Life as a Landlord library and look at your different location. And it's the same format. You already know what I'm going to talk about. So again, this episode is not all inclusive, and even if it was, 10 minutes after I record, it could change. So make sure you are doing your own homework applicable to you and to be the most current you possibly can be. But today's episode will definitely get you started. Now, if you're listening to this podcast, chances are you're either new to real estate or you're new to real estate in Arizona, or you want to be. Things you can do to help yourself are read the source documents, actually educate yourself on the Arizona Residential Landlord Tenancy Act. And two, get in the conversations with other Arizona landlords. You can either do that by physically entering a room, like at a meetup or a chamber meeting or a Rotary meeting or something like that, or Realtors Association meeting, Apartment Association meeting, something like that, or jump on social media into Facebook or LinkedIn groups where other landlords are having the same discussion and just say something like, I'm a new Arizona landlord, where are my other Arizona landlords? And they will pop out and help you. So make sure you're asking questions and you're educating yourself in that manner. Now, if you are new to the show, don't forget to subscribe for more expert advice and real stories from across the property and rental world. I'm recording this episode today from Westview Harbor in Powell River, British Columbia, because that's where my boat is. Why? Because real estate takes you places. Where do you want real estate to take you? Don't forget to subscribe for more expert advice and real stories around the rental world. I already said that, but that's okay. Join me next week for episode 174, and I'll tell you what's going on in episode 174 in 2 seconds because we got some fun stuff going on. Come on, what's happening? Episode 174 is... Ah, you don't know. I don't know either. I'll put a tail on this one here pretty quick. All right. Thanks for joining me. I will see you wherever that lands. Bye.